The coins alert is the source of all of the information that is described in this video. I would also like to remind you to give my channel a like and subscribe to it so that you can stay up to date on future XRP news as well as other cryptocurrency news in general. It is not anticipated that the SEC would challenge the judge's decision to impose sanctions in the Ripple case. The case has caused shockwaves to travel throughout the industry with each new development, which has influenced the sentiment of investors and maybe brought about a redrawing of the regulatory landscape with its ramifications. In this moment in time, it appeared as though the epic saga had found its conclusion. In terms of the subsequent actions, the case of the CCC has been struck a severe and decisive blow as a result of a decision that was made by a federal judge not too long ago. The judge has ordered Ripple to pay a penalty of $125 million, which is a significant reduction from the initial demand of $2 billion made by the agency, despite the fact that the Securities and Exchange Commission has not officially accepted defeat. The judge has ordered Ripple to pay the penalty. Legal experts are in agreement that it is extremely unlikely that the agency will launch an appeal. This is the consensus among legal experts. The journey has been full of highs and lows ever since the beginning of the lawsuit, which took place in the year 2020. A ray of hope was supplied for the cryptocurrency business by Ripple's partial success in July 2023, which stated that XRP is not a security when it is sold on exchanges. This victory created a glimmer of anticipation for the industry. A complete image, on the other hand, was difficult to come by up until this most recent chapter. An attempt has been made by the Securities and Exchange Commission to depict the ending as a win by utilizing the penalty and injunction that was issued against future violations of securities. On the other hand, the tone of the agency gives the sense that it is resignedly accepting defeat rather than sending out a rallying cry for more conflict. This is because the tone of the agency is not a call to arms. Ripple, on the other hand, described the verdict as a resounding victory and a monument to the rule of law, as stated by CEO Garlinghouse. Ripple praised the ruling as a monument to the rule of law. A number of businesses, including Ripple, expressed their delight at the decision. The chief legal officer expressed his relief that the court had rejected the exorbitant financial demands made by the Securities and Exchange Commission and that there were no allegations of fraud. He also commented that there were no allegations of fraud. An enormous upswing in the price of Ripple XRP is brought about by the second piece of news. An enthusiastic response has been received by the cryptocurrency market as a whole in response to the statement that the Securities and Exchange Commission (SEC) may be inclined to relinquish its position. An increase in the price of XRP can be attributed to the fact that investors have anticipated a regulatory climate that is more favorable for digital assets. It is still necessary to exercise caution, despite the fact that the focus has recently shifted to the potential ramifications that this landmark ruling may have on the cryptocurrency business. For the time being, the Securities and Exchange Commission has the ability to challenge the decision that was taken in July 2023, which partially endorsed Ripple. However, the breakthrough that occurred today is of fundamental importance in the ongoing fight that exists between regulators and the Bitcoin sector. This conflict has been going on for quite some time. A partial victory for the Securities and Exchange Commission was achieved in the form of a penalty and an injunction, despite the fact that the agency was not successful in achieving the entire scope of its initial requests. Ripple is still subject to an injunction that prevents future violations of securities law, which restricts the company's capacity to function freely. This is the case despite the fact that the punishment has been significantly reduced. What is the significance of this? Increasing investor trust and stabilizing the cryptocurrency market while clarifying legal rules for digital assets may be accomplished by reducing the penalty in the judgment that XRP is not a security for trading purposes. This decision is noteworthy because it establishes a key precedent for the regulation of cryptocurrencies. The Securities and Exchange Commission is likely to decide not to appeal the judge's verdict in the Ripple case. This decision is noteworthy because it establishes a precedent that is important for the regulation of cryptocurrencies. It is possible that Ripple and the United States Securities and Exchange Commission have not yet reached a conclusion to their legal disagreement about XRP. This is something that is still being considered. Stuart Alderode, the chief legal officer of Ripple, is of the opinion that the Securities and Exchange Commission may still pursue an appeal, despite the fact that a significant ruling has been handed down, which has the potential to redefine the landscape of cryptocurrency regulation. These words, which were made during a recent interview, reveal a profound level of skepticism regarding the actions taken by the CC and put into question the reasoning of the authorities' continual approach to cases involving cryptocurrencies. His remarks were made during the interview. During the course of his interview, Alderode expressed his confidence in the finding that XRP is not a security. This was in reference to Ripple's criticism of the technique employed by the SEC. This ruling has the potential to set a precedent for the manner in which digital assets are treated inside the judicial system of the United States of America. Nevertheless, he did hint that the Securities and Exchange Commission Secretary might continue to investigate the matter further, despite the fact that there are clear indications that the investigation ought to be ended. The Securities and Exchange Commission ought to just move on from this issue if they were acting rationally. In his statement, Alderati emphasized that the court did not discover any victims or damages that were associated with Ripple's operations. It would be reasonable for them to simply move on if their acts were rational. Also, there are no claims of fraud that have been made. In his remarks, he underlined that the case does not align with the principal objective of the Securities and Exchange Commission, which is to protect investors throughout the length of the case. Within the context of sex litigation, Al-Gharati expressed his disapproval. His accusation was that the regulator was participating in litigation gamesmanship and tactics rather than actually applying the law. In his statements, he brought to light a more general concern within the cryptocurrency industry, which is that the Securities and Exchange Commission's SE acknowledged that he was adopting a hostile approach against digital assets, usually without clear legal grounds. In addition, Ripple is looking forward to the attractiveness of the cryptocurrency. Despite the apparent success of Ripple, Alderati continues to proceed with an excessive amount of caution. He brought attention to the fact that the actions made by the SEC in the Bitcoin sector have not always been reasonable, which raises the possibility that the regulator may still consider appealing the decision. If the SEC decides to appeal, I wouldn't be surprised if they do. As he made his observation, he brought up the fact that the agency has a track record of exercising vigorous legal action in the Bitcoin market. In addition, Alderati gave his confirmation that the verdict that has already been rendered regarding XRP cannot be altered, regardless of whether or not an appeal is submitted. It is the law of the nation that transactions involving XRP are not considered to be security transactions. The position of XRP in the secondary market trading is that it is not a security. He took the position that this is the law of the land. It follows that an appeal would not result in a change to the precedents that this legal precedent has established. According to him, the fact that the appellate court reverses decisions reached by lower courts much less frequently than 10% of the time is a statistical fact that gives credibility to his stance of trust. During the course of the conversation, Alder had already raised concerns about the priorities of the Securities and Exchange Commission. In order to avoid pursuing what he referred to as a bogus lawsuit against Ripple, the Securities and Exchange Commission inquired about expanding its purpose, which conveys the impression that the regulator is departing from its mandate to protect investors. During the course of the discussion, Alderati proposed that the Securities and Exchange Commission of the United States should prioritize situations in which there is actual damage to investors or the market. While Alderati was considering the track record of the SEC in the case, he stated that this case was an overreach from the very beginning. In order to avoid engaging in what he considers to be pointless litigation that does not contribute to the protection of investors, he requested that the regulatory body return to its primary objective. The ideas expressed by Alderati have a significant amount of resonance within the greater cryptocurrency community. This community has regularly expressed its disdain of the Securities and Exchange Commission's SC sucker regulation, which it thinks to be severe. A potential appeal by the Securities and Exchange Commission could give rise to inquiries over the current legal standing of XRP, which would be unsettling for investors and the cryptocurrency industry as a whole. Ripple's victory would be only temporary if the Securities and Exchange Commission were to successfully appeal the ruling.